Good morning, this is your Kelso Report for Wednesday, February 20th. I'm your host, Clark Kelso. The United States Supreme Court issued 4 decisions yesterday, all of them fairly easy. First, it dealt with an issue of mootness in the context of an appeal from an order directing the return of a child to his country of habitual residence. Second, it dealt with a search and seizure case involving the warrantless detention of 2 men who were over a mile away from their apartment, which was being searched pursuant to a warrant. A third case involved what evidence a state needs to put on to establish the reliability of a drug dog's alert. And finally, the court had a Parker v. Brown state action immunity case under the antitrust laws. Well, let's get started with the mootness case. The Hague Convention on the Civil Aspects of International Child Abduction generally requires courts in the United States to order children returned to their countries of habitual residence if the courts find that the children have been wrongfully removed to or retained in the United States. The question before the Supreme Court in Chafin v. Chafin was whether, after a child is returned pursuant to such an order, any appeal of that order is moot. This was an easy case for the court, which unanimously reversed the 11th Circuit and held that the appeal was not moot. First, the mother and father continued to dispute where their child should be raised. So even though the child had been ordered returned to Scotland, there was still a concrete dispute before the courts. Second, the court still had personal jurisdiction over the mother who had sought return of the child to Scotland, so a reversal of the district court's order might result in an efficacious remedy, although there was no enforcement mechanism under the convention. Third, a vacature might reverse the trial court's collateral order regarding court expenses. And finally, the court noted that if it held to the contrary and dismissed the appeal as moot, that might make it less likely that trial courts would promptly order a child returned to his or her country of habitual origin, and that would be contrary to the general intention of the convention. So, for all of these reasons, the appeal was not moot. As I said, this was a pretty easy case for the court. Now we turn to 2 search and seizure cases. Now, as we all know, the Fourth Amendment guarantees the right to be free from unreasonable searches and seizures. A search, of course, may be of a person, a thing, or a place. So too a seizure may be of a person, a thing, or a place. And searches and seizures can occur singly or in combination and in different sequences. In some cases, the validity of one search can determine the validity of another. Well, in Bailey v. United States, the Supreme Court faced a situation where the search of an apartment dwelling led to the subsequent seizure of a person. But here, though it was acknowledged that the search of the apartment was lawful, the court held that the subsequent seizure of the person was not lawful. The precise issue was whether the seizure of the person was reasonable when he was stopped and detained at some distance away from the premises to be searched, when the only lawful justification for the warrantless seizure was to ensure the safety and efficacy of the apartment search. Factually, police officers conducting surveillance saw 2 men leaving an apartment for which the police had a warrant to search for illegal weapons. The officers trailed the men for about 5 minutes as they were leaving, and about a mile away from the apartment, they detained the men and returned them to the apartment. Well, in these circumstances, there was no factual basis for thinking that the men needed to be detained to secure the safety and efficacy of the apartment search. And that was the only legal basis for seizing them without a warrant. Accordingly, the court held that their detention was unlawful. If the police needed to secure the scene, they should have detained the men at the apartment building itself. Although even that would have raised a question since they were leaving the apartment building. Maybe the best thing to do would have been to get a warrant. Our second seizure case involves drug-sniffing dogs. In Florida v. Harris, the court considered whether an alert of a properly trained drug detection dog during a traffic stop provides probable cause to search a vehicle. The Florida Supreme Court held that the state must in every case present an exhaustive set of records, including a log of the dog's performance in the field, to establish the dog's reliability. Well, the Supreme Court rejected this detailed set of requirements as inconsistent with the flexible, common-sense standard of probable cause. Instead, according to Justice Kagan for a unanimous court, it's sufficient to introduce evidence of the dog's training and his proficiency in finding drugs as demonstrated by that training. In particular, the state had established that the dog at issue had completed a 120-hour training program in narcotics detection 2 years earlier, had obtained a separate certification from an independent company, completed another 40-hour training program 1 year prior to the search, and was trained 4 hours each week on exercises designed to keep his nose tuned for drugs. That evidence was more than sufficient to establish the dog's general reliability. Finally, the court had an antitrust decision. Now, the federal antitrust laws are, of course, designed to promote competition. However, under the Supreme Court's so-called Parker v. Brown state action immunity doctrine, when a local governmental entity acts pursuant to a clearly articulated and affirmatively expressed state policy to displace competition, it is exempt from scrutiny under the federal antitrust laws. In essence, the court treats it as though the state is itself acting, and the antitrust laws were not intended to prohibit state action. In this way, the federal antitrust laws make way for states to participate directly in certain markets free from federal antitrust scrutiny. Well, in FTC versus Phoebe Putney Health System, the court applied this doctrine in the context of a Georgia law that created special-purpose public entities called hospital authorities and gave those entities general corporate powers, including the power to acquire other hospitals. Although the statute created the entities as general corporations, the statute did not include permission to use those powers anti-competitively, or otherwise clearly express the intention that the hospital authority was supposed to be free from antitrust scrutiny. In these circumstances, the court unanimously held that state action immunity doctrine's clear articulation test was not satisfied. Merely creating a public entity and setting it off into the marketplace does not render that entity immune from federal antitrust scrutiny. Much more is required to trigger state action immunity. And that's it for today's Kelso Report. Have a great day in the law.